In a previous video, I made the statement that court hearings in probate matters, at least the hearings I'm involved in, are not going to rise to the level of drama or entertainment where anybody's going to make a movie over it. And I'm still going to hold true to that statement. I do want to talk about another type of court hearing that we very often encounter in probate practice, and that's what we call an heirship hearing. And understand, this is an heirship as in Heirship, not airship like the Goodyear blimp. But in an heirship hearing, the purpose of the hearing is to present testimony to the court so the judge can officially declare who are the heirs of the decedent, the person who passed, and also to determine the fractional interest that each heir is going to inherit. And it's most commonly used in a scenario where a person died intestate without a will, and we need an administration of the estate. And you may recall, there's other types of probates that you can do when somebody passes away intestate. You might have an affidavit of heirship, or you might have a small estate affidavit. But when we also need an administration of that estate, we're going to have an heirship hearing. So in this type of hearing, there are several parties involved. Typically, there's 5. There's going to be the attorney representing the applicant. In my practice, that's the role that I fill. You're going to have the applicant. That's the person seeking to be appointed as the administrator of the estate. You're going to have 2 independent witnesses. These are persons who knew the decedent, but yet were not related to him or her. But they knew them well enough to be able to provide sworn testimony regarding the decedent's family history and marital history. And then you also have a person called an attorney ad litem. This is an attorney appointed by the court, and their job is to represent unknown heirs and basically fact check everything that we have presented to the court to make sure that there are no legitimate heirs that have been overlooked or perhaps forgotten. So the testimony involved is going to focus on the family and marital history of the person who passed away. So we'll need testimony regarding every marriage that person may have had. When were they married? When did that marriage come to an end? Were any children born to or result of that marriage? And information about the children. If a child has passed away, we'll need to talk about whether or not that child left any descendants. So these would be grandchildren of the person who passed. If they were never married, we'll need information about the decedent's parents. If the parents are also deceased, we'll need information about their siblings. So you can see every situation is unique. And it's hard for me to give you an exact list of what would be asked in that hearing because I don't know the exact facts of your case. But it is an integral part of a probate practice when we need an heirship or we need an administration coupled with an heirship hearing.